Okay, so first we would like to invite Mr. Ezekiel and to give us presentations and to collaborate the relationship between the right to fair trial and the ethics skills in the criminal trial. So let's get very warm Mr. Proud to welcome the Mr. Skills with our presentation.
Thank you. Thank you. Good evening. Can everyone hear me? Okay?
Yeah.
Hear me in the back? Good. Because I don't like microphone. Too loud. What is a law in a country that cannot be enforced, if not an empty law? In the United States, we have constitutional rights that provide our citizens and everyone with the rights to a fair trial if they are accused of a crime. In our country, everyone is presumed to be innocent. I understand that you have the same in China now. In the United States, we have had several rights in our Constitution. All those rights were created in 1780 something, after the Declaration of Independence, and those rights gave each one of our citizens the right to the presumption of innocence, the right to an attorney when accused of a crime, the right to have a prosecutor prove the crime beyond a reasonable doubt. Not 51%, not 75%, not 80%, higher. We have also had the right of freedom of religion, the right to free speech, the right to own a weapon. We have many rights. Again, these rights were written in the late 1700s. And one of the very important rights that we have in the United States is the right, which will be involved in this case, is the right of every person who has been arrested and charged with a crime to not be forced to incriminate herself. Yet, in the United States of America, it was not until 1965, was that Miranda, 1965? 1965, that the great democracy of the United States enforced the right to not have someone incriminate himself. United States versus Ernesto Miranda. Why is that? Why do we have all these rights, all these theories that we love democracy, we protect people, yet we don't enforce them? So what do they mean? Nothing. It's like your boyfriend, your girlfriend says, I love you, but I don't know if you do or not. That's why in the United States, and that's why we're here, in the United States we have the right to have lawyers advocate for people. And in this presentation tonight, you will see a presentation from us on first, whether someone should be given bail or detained without bail, even though there's a presumption of innocence. You will see motions to have the government not use evidence that was obtained perhaps illegally, and statements, remember the Fifth Amendment, so they should not be allowed because they were obtained illegally. And you will see what a lawyer like myself, as a defense attorney in the United States of America, I have no power. Zero power. I am like one little grain of sand in a big beach. The prosecutor has most of the power. Most of the cases, the prosecutor says to his honor, I want to use this evidence against that person. He's a thief. He robbed $255,000. Put him in jail. The judge will say, yeah. What else would you want? What's a thief? Okay. So what do? I have no power. Maybe the judge will put me in jail. So today we're going to try to demonstrate to you what I can do for that accused over there, because the theory has to become the reality, or else it's empty. And through this program, what we hope to do, and Mr. Clear is the one that's driving this, and although I'm the famous lawyer from the United States, you know who is my master? So if I make a bad presentation tonight, it's his fault. Thank you.
Okay, thanks, Mr. Executive. So now we move to the second stage for the comments. So we have the mood. That's the for the mood. So would you like to give a reflection? Okay.
In this case, Your Honor, the defendant is charged with bank embezzlement and a false official statement to an FBI agent. There was a bank loss at a bank where the defendant, Wu Xingyang, worked as a part-time employee. He was a student at San Diego State University, and at the computer that they located, which was the source of the loss of $255,000, it was determined that only 3 people had access to that computer. As a result, the FBI, after determining the loss at the bank, commenced an investigation, and they sought a search warrant as to the 3 people that used the computer, including the defendant, Mr. Yang. As a result of that, they obtained from the court an official order of search of the house and the contents of Mr. Yang. At that house, they found a computer. They were not able to evaluate the computer at that time. They took possession of it and took it to their laboratory where they did a search of the disk. And on that, they found a transaction, a wire bank transfer, initiated from that computer to a Bahamas bank outside the jurisdiction of the United States, which sent, interestingly enough, the same amount of money, $255,000, to the bank. At that time, the government moved to interrogate the particular defendant in this case, and the FBI went out to interview him at the school. He was not in custody, and at that point, there was no need for a Miranda warrant. The standard, you have a right to remain silent, anything you can be used against you. That was not required. And he explained to him what was going on. There was some discussion about a lawyer, but not formally a request. And then there was a mention by the FBI agent that the man who was at the bank, our defendant here, was on leave. The bank, after he was indicted, formally charged with these offenses, to put him on leave, but he was still paid. And he said to him, "You're not cooperative with me, you may lose your job." Now, Mr. Yang is technically a student on a visa in the United States, and his status is under 2 holds, the criminal status and the administrative status with immigration. At this point, Mr. Yang told the FBI agent that he obtained the money gambling, and that this is how he got the $255,000. The FBI, as a result of that, went out and checked all the casinos. He claimed it was in Las Vegas, and they keep a record of any transaction for anybody earning over $10,000. It's done for tax purposes. There was no payment. Mr. Yang came up with the story later that he wanted it a private, and then later brought in a witness that said he witnessed him winning the gamble. The witness later admitted that Mr. Yang induced him to do this, and that he had lied when he made the statement that he witnessed the gamble. At that point, this case was brought, and now we are before the court on a bail determination. A warrant has been issued. Mr. Yang has been placed in custody, and now there's a prompt hearing. The first hearing, the judge determined detention, which means no bail is set, no conditions for release. Now we have this hearing with counsel for the defense, raising the issue that he should be released. He has a good record, a good background, but I, the prosecutor, am here to resist that, to ask that he be detained. Thank you, Your Honor.
Thank you.
May I give a little bit?
Yes.
Thank you. The defense side of the opening statement.
Hold on, just a minute.
Just a little bit.
Well, just to try to make just give the story. That's students is familiar with the
Yes.
story. Okay. So,
Yes.
wait a minute. So now we'll just okay. So please, yeah.
Thank you.
Yeah.
See how
You
it
heard
is?
what I mean about the prosecutor?
Okay, so the next is just the Mr. Clary and gave the Professor Clary gave the general introduction for this the whole story. Yeah.
Right, he starts the.
Yes. Okay. So actually, I will introduce today. So Clary is act as a prosecutor, and Ezekiel act as a defense lawyer, and Mr. Robert will be act as accused, the young, the students young, and I'm not just lucky to just sit here as a judge. So, and today actually we put on the demonstrations of 3 criminal trials and hearings, three. So this will complete 3 different stages. Okay, one is a bail hearing. So when the defendant seeks release after arrest. So then second is a suppression hearing. So where the defendant will seek to exclude evidence of unlawful search and involuntary admission. And the third part is a sentencing hearing. So where the convicted defendant is sentenced. So the defendant actually just I do not give the more details for the story because this Clary actually have already just told the story. So now, so we start our first session. Okay.
Yes.
Is that ready?
Yes.
Good. Yes. So on hearing the bail for the bank theft and the fourth official statements of the counsel ready?
Thank you, Your Honor.
So proceed, defense counsel.
Thank you, Your Honor. Your Honor, as you know, there has already been an order issued with a different lawyer defending this young man that he be denied bail. I'm going to suggest to the court that that ruling be reversed for the following reasons. Before you, you have a very young 24-year-old student at San Diego State University. He is the son of a very good family. His father is a professor, and his mother's a doctor. He has absolutely no prior criminal record. He is in the United States here on a student visa. That visa was taken by the FBI when he was arrested. And I am suggesting to the court that because the Bail Reform Act, the bail law, states very clearly that in all cases such as this, not a drug case or not a case of violence, that bail is presumed to be appropriate and that no excessive bail should be set. The prosecution before told the court that you should not set bail for a 24-year-old student with no prior criminal record from a very good family because he was a flight risk. If he were given bail, he would fly away, although he has no documents to do that. He cannot go to the airport, he cannot buy a plane ticket, he cannot go to Mexico, he cannot go anywhere without documents. And what I'm suggesting, Your Honor, is that because the Bail Reform Act does provide for bail, because in the United States we do have the presumption of innocence, and because there are alternatives to secure his appearance before the court, that the court modify the detention order and issue an order that provides the following. To alleviate the concern of the government, which is valid, to alleviate the concern that this young man poses a risk of flight, that you order that he be released on bail with a satellite tracker on his ankle. A satellite tracker that has a certain band that goes around the ankle that he cannot simply cut, because if he cuts it, there'll be a signal sent to the supervising pretrial officer. And at that instant, they will know that either it has been cut and they will immediately go searching for it. Second, that you require that the money that is in the Bahamas in a bank account the $255,000 be repatriated and deposited with the clerk of the court, and that the parents post $30,000 additional security to ensure his appearance, and that the parents who are in China sign the bail for him so that the professor and the doctor, very well respected people in the community, are putting on their word that their young man is going to appear in court. And just to the court for bail. Again, I cannot say enough that the Bail Reform Act presumes that someone will have bail with the least restrictive alternative. Thank you.
Thank you.
Yes, Your Honor. Very briefly, we start off first with the fact that the real issue in this case is, will he be present for trial? That is the first and foremost interest. That the interests of society must be protected because we have serious offenses before the court. The amount of embezzlement or theft of a bank of this amount is serious, in the range of about 10 to 15 years confinement. In addition to that, we have the lie to an FBI office. The absence of documents, the turnover of his passport, is not really valid because he can go to the consulate and get another passport. On the issue of the conditional device, we have a situation where he could go to the Mexican border, which is very porous, especially going south, cut it off at the border, be into Mexico on a plane in Tijuana and out of the country. If he is back in China, we have no extradition treaty with China. So there is no way to bring him back to the United States. So in this case, when we have to look at balancing the interests, yes, his freedom, there is the presumption for reasonable bail. In some cases, bail is appropriate, maybe in 30% of the cases. But in a serious case like this, given his status, a guest of this country, you have to weigh the dangers to society against that. I do agree with counsel's suggestion if the court decided on bail. I fully concur with his suggestion that the $255,000 be returned from the offshore bank and deposited with the clerk of this court. But before I agree to that, only if the court would grant bail, I would recommend to the court that detention, in light of the circumstances, and in light of the possibility and very strong likelihood that he might not be here for trial, that he be maintained for trial. Further, I would add that under our law, we have the Speedy Trial Act, so that he can request an expedited trial on the issue of this matter.
Okay, thank you. Your Honor, may I? Yes, very briefly. On the tracker, the ankle tracker, he cannot go to Mexico to the border, and the border is not porous. They have customs officers in the border in Mexico. So that the minute this young man moves 25 meters from where he's supposed to be, they're going to know that. He's not going to get to the border. But even more important, what compels bail here, and I would like the court to accept the prosecutor's argument that the only issue right now is risk to flight. How does one evaluate that this young man poses a risk that if you give him bail, he's going to flee? First, you have to consider what would motivate him to run, to flee. I submit to the court that we know that he will not. How do we know that? I'll tell you how. The sequence of events, as you know, is the FBI is told that there's some money missing from a bank. They investigate, they find a computer access to the bank. The FBI, with other officers, get a search warrant from a judge. They go to the young man's apartment, where there are two other young men who live there. And then what happens? They get everything they need, including the computer, they seize it, and they take it with them to search it. Because they don't have enough to arrest them yet. Listen to me. They do not have enough to arrest them yet. So they take the computer away to their lab, and then they search the computer. And then they think, okay, now we have probable cause. Let's go arrest him. But first, we interrogate him. What does that show for bail? You may ask, Your Honor. I submit a compelling fact that should compel you to set bail. Because if the risk of flight is the whole issue here, after the FBI left his apartment with the computer, with all these officers that showed up to scare the living lights out of him, he should have fled to China. What more compelling fact do you need that he does not pose a risk of flight? In fact, the opposite. He waited to be arrested. Thank you.
Very briefly, money is money. And in this case, we have $255,000 missing from the bank and $255,000 that he shipped out. Second, we have, when we get the computer, we have the authorization of the court. The computer is reasonably examined and it reveals that he sent $255,000 to the offshore bank. And so in this case, we have more than probable cause. But we have even more of his guilt, an issue not to be addressed here because we're only speaking of probable cause, in the sense that
Your Honor, I will object with due respect to counsel. This is not a trial. This is a determination whether he has a propensity to flee. I'm stipulating that as a condition of bail, this young man will surrender the $255,000 to deposit it with the court to be secure. The only issue here is risk of flight. This is not a trial.
Okay, yes, it's a response to the risk of flight.
The major issue on the flight is, and about point I was about to make when I was interrupted by defense counsel, was that the issue is his also veracity. We see that he lined up a false witness to cover him on the gambling issue. So we have, first, the missing money. Second, we have the same amount of money being transferred offshore. Third, he lies to the FBI agent. Fourth, we lies another witness who admitted he lied to cover him on the gambling. He wasn't with him. That I give it in these circumstances, and I'm not here to argue, counsel is correct, the issue of only the question of probable cause and the risk of flight. When if he returns to China, he's home free. I think that the interest of this country in having a serious violation of this man requires that this court can only detain him.
Yeah, no, Your Honor, I will submit.
Yes, sir, so you will submit. Okay, so before that, so can I just ask a few questions about it? So, has the accused just surrendered his passport?
He had a visa. He did not have a passport.
No passport. Yes, and visa. Yes.
They took his visa, his student visa.
It is a visa.
So he has no travel documents.
No travel documents. Okay. So, you have an question. I just probably get asked just to respond to that because he said the risk of flight, but now you just said his lies to the FBI.
He lied to the FBI, which is the issue in this case.
Yes.
But more importantly, and this court can consider this issue on the matter of bail, is
Okay.
that he obtained a friend to say he was with him in Las Vegas
Yep.
when he won the gambling.
Yeah.
And he lied about that. So the story about how he got the money was a lie.
Okay.
And so now, when you hear the bail petition, you have to determine his character and honesty for the purposes of determining whether he will appear for trial. And I think in light of that, they've been compromised completely.
Okay. Yes, please. Yeah.
I believe it was Alice in Wonderland, Your Honor.
Yeah.
You put the cart before the horse. First, we have the hanging, and then we have the trial.
No, the trial.
We have not had a trial.
Yes.
So no one can say that he lied.
Yeah.
He's presumed innocent. You cannot assume on a probable cause standard that he lied to the FBI. We don't know. We have not had all the evidence for a trial. So
Okay,
that is
that's
not to be
okay.
considered.
That's good. Thank you, sir. Thank you. Okay, so I give a position. So generate the detention and it's a bail on the okay. Probably I think we just bail on the conditions such as ankle GPS. Okay? and also cash bail. So he should pay. Now it's less, probably just $300,000 US dollars. Okay, it's okay. The point okay, so this is a trial for the English, just for the fair trial. So they actually is a very just good expert in this sector. I'm just the layman sitting here, just try to maintain this order. So now, probably you can have any questions. For example, probably why in this bail hearings. So what's the main issues? We should know what comes here the balance, what we need to balance. And what skills should we need it? So in order to just, to make sure that this the accused should be bailed out, not just stay in detention, in the custody for the waiting for the just trial. So you can have questions, or I think the first counsels, if you can just to give a little bit more just explanations on this bail hearing.
I will refer to, anybody have questions?
Anybody have questions? Did you understand everything that happened?
We'll have questions at the end if you'd like. It makes it easier.
May I ask you a question?
Yes.
Thank you. Let me ask you a question. There was a prior ruling that he should be detained, and he had a different lawyer. Right now, do you think he should be detained without bail or not? How many hands say detained? How many hands say release? Good. You see, this is the role of advocacy. Unfortunately, some lawyers are not very good. I had a great teacher, he's sitting right there. The tragedy of the American system of justice. Everyone hear about the O.J. Simpson trial? O.J. Simpson was guilty according to everyone. He was guilty. Overwhelming evidence. So what saved him? The lawyers. Arguing for him to a jury that was ready to accept his version. So my question to all of you is this: do you see what advocacy does? Anybody? Why? Let me ask you a question then. Why should justice depend upon an advocate? Why doesn't the judge do the right thing on his own? Anybody? Nobody wants to speak to it. It's okay. It's okay. In the United States, this is very common. Sometimes a different lawyer will come in and get a completely different result. Why? Simple. Human nature. I'm speaking to this judge and I'm trying to figure out what does he want to hear from me. So I hear something from the prosecutor that we can do, so I'll grab onto the prosecutor, and then he hears something from me that he likes to hear. Let's bring back the $255,000, and then he may agree to bail, and then the judge, persuaded by both of us, or maybe him seeing the light over there, he sees that the parents have $50,000. So $255,000, that's how you come up with $300,000.
Yeah.
Very nice. See, he was the advocate. That's how it works.
Yes. So my concern is that it's actually say when you said he's actually it's not possible just to fly back to China, because when he had opportunity to fly, he did not fly. But he also just mentions it's not good because there's a false lie just to even though we have no trial, we not prove that. But this is also information.
Correct.
So that's why so the possible is that put together we use is that it's a strategy to not put it into the custody but have the ankle GPS. Ankle GPS we know. That's you can just surveil GPS, so we can just trace him just where he is. And then just put the money because he wants his money. So let him just to be supervised and also try to secure the loss of the bank. And if he fly, anyway, just then put him into do not put him into custody. Let him free just outside the custody. So this is what I am thinking. So this is the problem. Is both sides is just try to convince. give them more information and to make the judge to have the reasonable, just the judgment. So which you try to put, I think the balance could be struck by the judge. So even just prosecutors and also defense counsel, so they also just try to give them more information and all his arguments or his perceived or just his understand the categorization of the facts just to the judges. But they are actually, I think, they are just from his own position. To some extent, it's a little bit just to say, okay, a bias because from his own positions. But of course, he wants to make his arguments, his facts, is more persuasive. So that's just okay. Judge should be to be heard and to understand and to accept his arguments. So this is probably the most important things for the counsels or defense lawyers or the prosecutors the job to do in the court. But of course, in the different stage for the criminal procedures have different rules and different requirements and different purpose. So you definitely also need to follow the law. So that's why. So the defense counsel to remind me, okay, so this is not trial. I'm just put something not like the trial. So this is actually only just for me, like the lay judge could be the mistakes to be made by this lay judges. But for the very experienced judges, normally do not make such this kind of the mistake. But here it says we need to understand why, let's say, what is a trial, what is not trial. So how to make the judge distinguish to that? What's the standard? So I would like to ask the SQ to please a little collaboration about what is trial. Why do you think this is a trial? Why is it before that it's not trial? It's just for the bail hearing.
Thank you.
Thank you.
Very good question. What we have today in this demonstration is a pre-trial hearing. The prosecutor is concerned that if bail is granted to this young man, he will flee. The prosecutor has probable cause that he is guilty and he committed the crime. Probable cause is 51%, more likely than not, 51%. However, the prosecutor at the bail hearing has not presented witnesses. I have not had the opportunity on his behalf to confront and cross-examine the government's witnesses. So the defense has not had the opportunity to test the government's case. The difference between a hearing like this and trial is incredibly radical. At trial, the prosecution has to summon all his witnesses, including the FBI agent. And I get an opportunity to hit them, to cut away at everything they have, all their evidence that they have. So at a bail hearing, it is incredibly unfair for a judge to allow a prosecutor to jump ahead and say, trust me, he's guilty. Trust me, he lied. Trust me, he wasn't cooperative. No, we don't have evidence. We have arguments of a prosecutor. So at trial, that's when the flower of the criminal process blooms. Because a trial, both sides, we don't have to present any witnesses at trial. Okay? We don't have any burden. Because the client begins trial with a presumption of innocence. What does that mean? Graphically, simply, starkly. It means that if you have the scales of justice, imagine it in your mind, the scales of justice, okay? The trial begins with one side completely weighed down and the other one up here. This is the prosecutor side. So the trial is for the prosecutor to present witnesses, present evidence, to begin to push that down. That's probable cause. That's 75%. That's 85%. Not enough. That's 90%. Maybe that's enough. So if the standard for proof of guilt that he lied, remember the charge. This is why it's such a critical proffer, when a lawyer says something to the judge with no evidence, it's called a proffer. I proffer to the court that he's a liar. Okay? What is he charged with? One of the charges is embezzlement. Okay? The other charge is lying to an FBI agent. So if the judge accepts on a very, very light level that he lied, you already have a finding of guilt. That's completely unfair. And that's why we have trials in the United States. And the burden of proof, let me tell you how it works practically. So 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. You 12 will be the jury. And then the prosecutor, he's a very good prosecutor. I'm afraid of him. He's going to make my client cry in a few minutes. If he presents his case and he begins to bring down the other side of the scale, maybe 11 of you, 11 when you go to deliberate, evaluate, 11 say, I like Mr. Cleary. I think this guy is guilty, and I'm embarrassed at him. He's Chinese, I'm Chinese, I want to convict him. And that little lady over there, she said, no, I don't think he's guilty. He's probably guilty. He looks guilty, but I'm not convinced beyond a reasonable doubt. Guess what happens? 1 against 11 wins. He must be acquitted. That's what.
Well,
So
objection?
federal system. This is a federal case.
You said acquitted.
No, he's a hung jury.
Oh.
I stand corrected, Mr. Clerk. Let me tell you what.
Big mistake.
No, it's not. And he trained me. I'm going to prove him wrong right now. He has to prove that he's guilty, does he not? Yes? If one juror does not believe it, and he begins presumed to be innocent, at the end of the trial, what happened? He failed to prove it. Although in the United States we have a rule that says that's a hung jury. That's what we call it, like you hang the jury. The jury can't decide, okay? If it's a hung jury, you have to try the case again. It's absolutely right.
Okay, thank you.
Thank you.
So, any other questions? For the audience? Any questions? Yes, please.
We have a trial hearing, so this prosecutor he used a lot of evidence, but you use this young man, his whole family, his students, so this is not, I have to say, evidence, it's just about his characteristics, but he used a lot of evidence. Is that evidence should be used in a trial, and this hearing is just about if he will wrong or not, we can just know that from his characteristics?
Very good question. My answer is, I'll make it simple. Neither the prosecutor nor I presented any evidence. It's argued. But the law presumes, in a case like this, that bail should be set. So we begin with a presumption that he should have bail. The issue is there sufficient guarantee that will make him show up in court? His character, and the prosecutor can argue against me with the character issue. And I open the character issue. He's a young man, his parents are good, he's a good student, so he can attack the character issue. And he can argue that the statements to the FBI agent are false, so he's a liar. So what Mr. Cleary was making, it's actually a very compelling argument. But he didn't win. So don't change your mind. The compelling argument is this. And that's a very good question, young lady. Because all I have is reputation. That's illogical. Okay? But Mr. Cleary gave a great answer about 5 hours ago. The life of, it's not logical that a character would carry the day. But we have a famous judge in the United States from a long time ago, Oliver Wendell Holmes. And what did he say, Mr. Cleary?
The life of the law is not logic, but experience.
Experience. So that the character of a defendant should be sufficient to assure that he's not going to flee. So why do I have a bail? Almost nothing. But according to the bail, it's called the Bail Reform Act, and it has a